Welcome to Essential Estate Experts, the estate planning podcast and ultimate resource for understanding estate planning and elder law, brought to you by Screenfire Media. Let's get started.
Hey there, folks. Chuck here, and welcome to Essential Estate Experts. I am so glad you're here today. We have got another great episode coming up where we break down the myths and misconceptions that happen when it comes to planning your future, planning your estate. And this time, we're taking the estate planning to the state of Texas. But before we get too much further into that, I need to make a quick note. We ask that you please be aware that the information provided on Essential Estate Experts is for entertainment and informational purposes only. Listening to this podcast does not establish an attorney-client relationship. Always consult with a qualified lawyer before making any decisions related to legal matters, and do not take legal advice from a podcast. All right, now that we got that out of the way, we're going to jump over to introducing my co-host, Mr. Mark Zasada. Mark, how you doing today?
I'm doing great, Chuck, and looking forward to talking to Steve Clausen today.
All right. Well, without any further ado, we're going to introduce the man of the hour, Mr. Steve Clausen. How you doing today, Steve?
I'm doing well, thank you.
All right. Well, Steve, you're with Hopkins Centrich over there in Houston, Texas. So let's get started by you telling me a little bit about yourself and how you found yourself where you are today.
Well, if I did all that, we'd be here a couple hours, so I'll try to condense the story a little bit. I'm originally from the Midwest, and I started my practice in Kansas City with one of the large corporate firms in Kansas City, and practiced there 3 years as a corporate attorney. But I still had the desire to do tax and estate planning work, and I ended up moving to Texas to a large Houston firm. Then in the last few years, for family reasons, I went to a smaller firm and have more of a boutique practice because there's a lot fewer demands on me than being a partner in an extremely large firm.
People who listen to this show know that there's nothing dull about estate and tax planning, however those words may sound. If you've read Shakespeare, there's plenty there about family succession and passing on instances. Steve works also in business succession. But a big piece of our subject today is Texas. We want to really drill down and learn, how is estate planning different in Texas? If I were moving to Texas, which plenty of people, I'm in California, plenty of people are moving to Texas these days. What's different there? What would I need to know about estate planning in Texas?
Okay, well, I'm going to cover you moving from California, and I'm just going to put Chuck in Missouri. That Chuck is going to move from Missouri to Texas.
Great.
Because the fact pattern's entirely different. Mark, you would be coming from another community property state. Texas is a community property state. So we have community property and separate property in Texas. Separate property is property that you acquire either in a common law state like Missouri, where Chuck lives in my example, or you inherit property or receive property by gift, or you can partition community property and make it separate property, and recovery for personal injuries is also separate property. Those are the basic classifications of what's separate property in Texas. Everything else is community property. Here in Texas, income from separate property is community property. Contrast this with California. I've done a lot of work with California residents coming into Texas. California is a community property state, but the major difference in California is income from separate property is separate property, while in Texas, income from separate property is community property. So if you moved to Texas, Mark, and you were my client, one of the first things we'd be doing is you would have completed my comprehensive questionnaire, given me the necessary family information about yourself, given me the information about your financial situation, your assets, and your goals and objectives. I would look at the financial information to see how thorough you were and whether you've listed property as community property or separate property, because you could have both coming from California. If it wasn't clear what you owned, we would drill down, and I would eventually get satisfied that I know what you've brought into Texas, so we could plan with that property.
Let's make a hypothetical example here so that it's more clear what we're talking about. So let's say, I'm Joe and I'm married to Mary, and well, let's not use Mary. That's going to get really confusing. I'm married to Joyce, Joe and Joyce. Okay.
Mhm.
And I own maybe it's a second marriage. I own a business and I take that income as separate property in California. So this has nothing to do with Joyce. We keep separate bank accounts for the business and so on. Now, apparently in California, it's okay. I keep that income separate. But you're telling me if I now move to Texas, surprise, that income becomes community property automatically? Is that what I'm hearing here?
Yes. As soon
Wow.
as you establish residency in Texas, that income that was formerly your separate property is now community property. Now, if you don't like that result, we could have you execute a marital property agreement where you and Joyce agree that the income from your separate property in Texas will now be separate property rather than community property. But
Okay, I get it.
if you do nothing, it's going to be classified as community property here in Texas.
So, this I think is a continuing theme on this show where people they don't look into what happens when you move into another state. And they make assumptions that, oh, nothing's going to change. I own this business. I have these bank accounts set up. They don't realize they're moving into a different set of laws that may change everything. And they really got to talk to a lawyer if they have a complex situation at all.
Well, they should. And it's better to talk sooner rather than later than go on to do too many things. Because one of the concerns that you will have then in your situation is you could reinvest your separate property earnings into other property, and it'd be separate property. Here in Texas, now because that income is community property, you start investing that income in other things, that also becomes community property. So if you don't like that result, you need to take planning action sooner rather than later.
And I better have this conversation with Joyce in a really nice way so we don't have a big argument about it too.
Well, it works the other way too. If she has separate property, then it works for her too.
Okay. All right. Now I'm going to let you talk about Chuck coming in from, what'd you say, Missouri?
Missouri. Missouri loves company, so I'm coming down to Texas.
You're right. I'm also admitted in Missouri because that's where I started practicing law, and I've kept my license active. Chuck's coming in from Missouri. It's a common law state. So let's just say Chuck had a house in Missouri solely in his own name. Under Missouri law, that is Chuck's separate property. Now, Chuck comes down to Texas, buys a home. Let's just assume Chuck puts it in his own name. And that's all it says. The deed is to Chuck. Well, the presumption in Texas is when you're married, all property acquired during marriage is community property. And the person claiming that it's separate property has the burden by clear and convincing evidence to establish that the property is his separate property. Let's say Chuck wanted to maintain the separate characterization of his house, and his deed just shows Chuck rather than Chuck as his separate property. That would be the way we would suggest the deed be taken. Well, if it just says Chuck, we've got the presumption now it's community property. So Chuck's records would have to show that his separate property funds coming out of Missouri were used to acquire the house. If he can do that, then the house is Chuck's separate property. And the significance of that is, in Texas, in a divorce proceeding, separate property of a spouse is not subject to division in a divorce proceeding. So if Chuck can show that house is Chuck's separate property, he does not have to worry about any portion of that house being forced to be sold or value going over to his wife. But if it's community property, then it's subject to division. I'm going to throw in a complicating factor. Let's say Chuck decided, well, I don't want to put all my money from the Missouri house into the Texas house. I'm good making a 20% down payment. So I use my separate property money for the down payment, and I get a loan here in Texas for the balance of the purchase price. Well, under Texas law, that loan is going to be considered community credit. And so you've got 20% of the purchase price separate property. Now 80% represented by the loan is community property. Now you've got a bifurcated asset, 20% Chuck separate property and 80% community. So if Chuck had met with me before he moved to Texas, which most clients just don't think that way. Mm-hmm. But if Chuck had, I would explain his options regarding the house and how he would take title to it and the different ramifications. Separate property, not subject to divorce. Community property, subject to divorce.
Got it. Wow. So that, this again, like people just blunder through these things. They walk into a bank, they take a loan, like who's on the loan? It's just kind of, they make the decision in the moment, not realizing they can have lifelong implications for them, their spouses, their kids.
The homestead rights in Texas are a great tool. Let's just take this house that we've been talking about with Chuck. That's his separate property. And Chuck got children by a prior marriage. And Chuck's will says, I leave my house to my two children equally. So 100% of the house goes to Chuck's children from the prior marriage. Okay. But Chuck's current spouse has a homestead right in the house, despite what Chuck's will says, and she has the right to live there for the rest of her life without being bothered by Chuck's children. Now, under that homestead right, if there's a mortgage on the house, then she's got the obligation to pay the interest on the mortgage because the mortgage was in Chuck's name, but his children have to make the principal payments on the mortgage. Wow. As a homesteader, she has the obligation to pay all the real estate taxes. The obligation to insure the house generally falls on, in this example, Chuck's children. But because the spouse wants to make sure she's got a place to live, from a practical matter, most spouses will pick up paying for the insurance policy because they would be out in the cold if that house got burned down. So that's a little tweak people need to know about, that you can own a house and want to give it to your children, but if you've got a spouse, that spouse is going to have the right to live there, even for their life, even if you leave that house to somebody else.
Wow. That's probably something a lot of people don't know about and takes them real by surprise when there's a second marriage and a new spouse. And guess what? Father dies. I own the house if my father dies, but I can't do anything with it until the new spouse passes away.
Right. And the problem then over time, because people won't want to be making improvements to the house. The spouse has the obligation to keep it in good repair. But wonder if they don't. Now you've got children suing the spouse for failure to keep it in good repair. Let's say the house needs improvement. Children aren't going to want to make the improvements because they're not going to benefit from the improvements till way down the line when the new spouse passes away. Let's say now, for whatever reason, the surviving spouse wants to move. It takes the consent of both the surviving spouse and the children from Chuck's prior marriage to agree on the sale in order to sell the house.
So the children often end up like paying off the spouse
Yeah,
to get them to agree to
well,
leave. Yeah.
exactly what happens a lot of times. There will be a settlement agreement where it's usually the spouse buying out the children so that the spouse owns the house. Because
Oh,
let's
okay.
let's just say there's a 30-year difference in age between the spouse and the children. The children aren't going to see any economic value for 30 years, given the age difference. You will go to the actuarial tables usually and work out what the life estate is worth, what the remainder interest in the house would be based on the respective ages and the applicable federal rate, and then come up with a number to try to buy out the remainder interest. But it can work the other way around. The spouse could decide she wants to be bought out.
So this is called the homestead law in Texas.
Yes, the homestead is in the state constitution.
It's to protect people so they can live in a house.
Right. It's to protect the surviving spouse that they always have a place to live.
That's amazing. One question I always have is do wills have a lot of force in Texas, or do you also really need a living trust?
I'll go through the probate process here in Texas.
Okay.
They leave a will, they're going to need to take it to an attorney.
Okay.
And the attorney is going to prepare the application to probate the will. That will be filed with the county clerk of the county in which the person died. Probate is the legal process where the validity of the will is determined and is given legal effect. Until a will is admitted to probate, it is a piece of paper. It has no legal consequences. So in the probate process, after you file the application, there will be a hearing in front of a judge. Testimony will be presented regarding the decedent and the will. And if you've complied with the statutory formalities and there's no contest, then the will be admitted to probate at that hearing. If somebody contests the will, then you have real litigation that has to be resolved in order to get the will either admitted to probate or it's determined not to be a valid will.
It sounds like a lot of people could very easily fall into the trap of not connecting these dots. And it sounds like it's something that happens, sadly, far too often. So, what happens when this stuff goes wrong? What is the process? Does it go to probate court? How does that action usually play out?
The way it plays out is they're going to want possession of the property.
Mm-hmm.
Okay. They're going to have to show that they're legally entitled to the property. So if there's money in the bank is not going to give them control of that bank account unless they can show they're legally entitled to have the bank account.
Mm-hmm.
Let's say there's real estate and they want to sell the real estate. They have to show that they have become the owner of the real estate. That ties back to the probate process. If there's a will admitted to probate and they're named the beneficiary and an estate administration's been completed, then they're going to own the property and do anything they want with it. If there is no will, then you're going to have a determination of heirship, where the court's going to determine who the decedent's heirs are. And there will be a judgment entered saying these people are the decedent's heirs. Now they will own the decedent's property. So that's how people will find out there's a problem once they start trying to do something or take control of property and they can't show they are the legal owner.
That sounds like it would be a real pain. I imagine this would play out over months, if not years.
Well, it depends on the asset. I mean, for example, if it's a house and somebody just goes there and is in it and no one's trying to push them out and they're paying the tax, so the taxing authorities are leaving them alone. That can go on for years. And what you will see happen sometimes, people won't do probate. Let's say in the parent's estate, some child moves into the house, the child dies, and there's no probate done in the child's estate. And now some grandchild takes over the house, and eventually they want to sell it. And the title company will run a preliminary title report and will see that the house is still in the name of grandmother and grandfather. No probate's done on either one of their estates. So now you have to probate their estates. If they died too long ago, then there's going to be a problem getting their old wills admitted to probate. Texas has a general law that a will must be presented for probate within 4 years of the date of death. If it is, and it's a valid will, and you can present the necessary testimony, you can get that will admitted to probate with no questions asked. Once you go beyond 4 years, then you don't have the absolute right to get the will admitted to probate. You have to notify all the persons that would be the decedent's heirs if there was no will, and they have the ability then to contest the probate of the will. And for example, in a situation, if you've got a second marriage and the will's leaving everything to the surviving spouse, and the children from the first marriage are disinherited under the will, and there's not good family relationships, those children are going to then fight to try to prevent that will from being admitted to probate.
In other words, a big mess, a big mess.
It's a mess, and the moral of the story is, if somebody dies with a will, they need to see an attorney sooner rather than later, but in no event do they want to wait more than 4 years, because then they bring in a whole other raft of problems that have to be addressed.
Got it. Should you have a living trust in Texas, or is a will good enough?
It depends on the person's situation, how much they value privacy and want to avoid probate. Texas has relatively simple probate laws if you provide for independent administration with an independent executor, because that executor operates free from court control. But if you don't have independent administration and you have dependent administration, then it's subject to court control. You need an application in order to do things. So a well-drafted Texas will providing for independent administration is going to make things relatively easy for an executor to administer the estate. But here's the practical problem we've seen as a result of COVID and the population increase in Texas over the last 10 years. Our probate courts are overburdened because of the size of the population. In the old days, I could file a will for probate on Wednesday in Harris County, and within 2 weeks, I would have my probate hearing, get the will admitted to probate, and my executor appointed. Now in Harris, for example, depending which one of the statutory probate courts you're in, Harris County's got 5 statutory probate courts. You can have a wait of 2 months or so before you have the probate hearing. Some counties are much longer than that. For a lot of states, that's very impractical for a lot of reasons. Whereas if you do your planning under a revocable trust, you're calling it a living trust. They're the same thing. And you fund the assets to the trust during your lifetime, then your trustee, whoever that is at the time of your death, can start dealing with those assets immediately. There's no waiting for a probate court to bless your trust. Most of my clients do their planning under a funded revocable trust because we want to avoid probate, we want privacy and speed to deal with the assets. And the revocable trust is much better for asset management if the owner becomes incapacitated during their lifetime. Many financial institutions do not like durable powers of attorney for an agent to try to manage your assets while the successor trustee under a revocable trust, they're used to dealing with trustees. So that's another reason we use revocable trusts a lot.
Oh, that's very interesting. I hadn't heard that before, but I could imagine a bank being a little worried about someone having durable powers of attorney because what are the limits and so on.
Oh, it's very difficult with the big national banks dealing with them with powers of attorney.
Interesting. That's really. I think sometime we're going to have on the show someone from a national bank to talk about their perspective on dealing with trustees and powers of attorney and I had one bank person to complain to me that like the problem is every lawyer does this differently, so every trust I look at is different, and we got to figure it out every time. And then I talked to a lawyer, and they say, "Well, that's just tough, guys. That's the way it is. They're all different." I know you do work on business succession and particularly family business succession, so I'd like to hear a little bit about that and some of the issues that come up. What kind of work is that?
Well, family business succession is at the end of the day, who takes over the ownership and management of the company when the founder dies. That's the first generation to second generation succession planning. And oftentimes it's going to be the same person that becomes has control from a management standpoint as well as the ownership. Now, succession planning is complicated for a variety of reasons because you've got the intersection of the family dynamic system with the business dynamic system. And there's all kinds of complications that arise where the two systems collide with each other. And so you have to look at where the founder is in their stage of life and what they've done to that point. Are they a few years away from retirement? Are they 15 years away from retirement? Do they have a successor actually identified and they're going through the process of training them? Or do we need to identify someone and then institute, a training program for them so that they're able to handle the tasks of being the owner? We have to look at the family situation. Is that family business going to be necessary to take care of the surviving spouse? Has she been in the business? So are we going to have to leave the business into a trust for her benefit and maybe have, one of the children, manage the business? So there's a lot of moving parts. So a big part of the process is getting the necessary information to get a good handle on the family itself, the financial wherewithal of the company, the other assets of the owner, and then what the owner's objectives are. Now let's go back to the twist, the community property system. Remember I told you all property acquired during marriage is community property in Texas, unless the party can show it was their separate property. So if mom and dad started this business during their marriage and dad dies first, at the death of dad, mom owns the business. She owns half the business. So we're only dealing with dad's part of the business rather than the whole business. So you have the complications from that end. So there's just a lot of moving parts with family businesses.
There must be a lot of times when somebody dies and suddenly a spouse or a child owns a business which they have no idea how to run. I mean, it takes years to learn how to run a business of any kind, really.
That's the no succession plan.
Yeah,
Okay.
the no succession plan, which probably happens a lot, the no succession plan, right?
Or a poor succession plan.
Okay.
Between no plan and poor plan, you cover most of the businesses, because
Yeah.
real succession planning takes a commitment of time, effort, and money to have a good succession plan in place for a real business. I'm talking about a real business, not something that was, in effect, a job for dad. I mean,
Right. Right.
you have a lot of small businesses at the end of the day have created a job for dad, but there isn't really a business to pass on.
Yeah, sure. Probably a lot of professionals have something that's
Well, right.
just them.
So,
It's really a solo practitioner kind of thing, or a freelance artist, or something that's not really a business. But if it
right.
is a real business and there's employees and all that, I mean, somebody's got to know how to run that. And, to suddenly own something that you have no idea, that's kind of shocking for everybody.
Well, and that's how businesses get run into the ground, because you don't have someone on board who really knows what they're doing. Because third parties get nervous if the business has got loans out, the bankers are going to be concerned. Got to make sure the loan documents aren't drafted in such a way that the loans become due during death. Let's say dad's guaranteed some of the business loans. Most
Wow.
guarantees are drafted, so at the death of the guarantor, the loan becomes due.
Oh, my goodness.
So then you have to try to refinance.
Wow. This is the kind of thing somebody's signing up for a business loan, and that's part of the standard language, and they just sign it, and they don't think about the consequences. Maybe they're in poor health already, but yeah, what's actually going to happen when I die? What's actually going to happen? I think very few people think that through, even business owners. How long does it take to plan for business succession? It's not something you're going to do in a month and figure out who's going to run a business.
There's no hard and fast answer, because it really depends on if you're dealing with a family that is used to planning during life, and they've been through processes, that they have a good estate plan, they're used to dealing with professionals, so they know it's going to take money, time, and effort, and they've got a successor identified. That's one situation. The other situation is a very successful business that's kind of outgrown their advisors. The founder or the owner is a little too thrifty for professional help, and has hung on to control too long, and now you don't have you haven't really done any groundwork for succession. That is a much more difficult situation to deal with. And then you have the issue of time. How much time do you have? Is it because dad's been diagnosed with cancer now that he's finally willing to do planning? Or is there, some other catastrophic event that's pushing it? Or are we brought in and we can do things in an orderly way? It takes considerable time to get all the information that you need in order to really start formulating a plan with options. Because you have to understand the family dynamics. Who's going to be in the business? Who's outside of the business? Is all of the business going to, for example, children who are operating the business, and now you're going to try to find other assets to go to the children outside the business? Or is the business so much of the estate that you're going to have everybody owning a chunk of the business, but only a couple of them are actually working in the business. All these kind of factors influence how long it takes to get something done, what it is you're able to do, how happy people are going to be with the end result. I mean, a lot of times what you're trying to do is treat people equitably, realizing you can't treat them equally.
I think that's a really important point. One question I always have is how much should parents plan with their adult children? What's going to happen when they die? I mean, I don't think very many people do that sit down with their adult children and say, here's what I'm planning. Does this make sense to you? Or, it's kind of a big secret until the will is read, mostly, right? Do you advise people to have those, or is it just going to lead to trouble? They even try to have the conversation before you die.
I'm going to give you a legal answer. It depends.
Oh,
It depends on the family. But here's one thing I can tell you for sure before I give you a little more detail. You do not want to have these discussions over Thanksgiving or Christmas around the table.
Quick way to ruin Thanksgiving dinner.
When that kind of stuff is discussed and there's something somebody doesn't like, and you go from having a holiday to a battle. So you don't want to do it over the holidays. Now,
Okay.
whether that's based on experience. Okay, I've
bet.
learned that over time. Now, a more specific answer is it depends on the family dynamics. Is this an open or closed family? Have they shared information before, or is it completely not sharing information? Do you talk about the big picture? This is kind of what we're thinking in mind, and the lawyers have worked out all the details, or you get into how much you get into the nitty gritty, and that all depends. Now, if you have a family business involved, almost by definition, you are going to have to share what's going on with the business, because there are a lot of people that are affected by what happens to the business. You have the immediate family itself. If there's a surviving spouse, oftentimes that income from that business is going to have to go off to the surviving spouse to support the surviving spouse. If you've got children in the business, you got a couple of them. Well, who's going to be the chief? It's very hard to have two chiefs. Usually, a decision has to be made that one child is going to be in charge. And how's that going to play out? Now, are other children going to own a piece of the business? So as you can see, depending on the personal relationships and the complexity of the business, there's no one way of doing things that fits everyone.
I realize it's all different. One question I've had, is it better to not have a group conversation, but to talk to each child individually about the situation? Do you understand what I'm saying? Like, never try to avoid a group conversation.
I understand what you're saying exactly. I think there's a lot to be said for the individual conversation, as long as the parent's being candid.
Yeah. Okay.
And not telling a child what they want to hear, and they're really doing something different. So when I always use dad passing away first. When dad passes away first,
but
and things are in place, one child says, well, dad told me he was doing this, and now I find out he's doing that. With a group conversation, at least everybody is hearing the same story from the parents, versus the parents maybe shading the story to accommodate what they think the child wants to hear, so that they don't necessarily have to have the real conversation with that child. Think about in terms of, let's say, the oldest son is being bypassed to be president of the company, and his younger sister, who has went to Harvard Business School, has went into the business and has worked like a dog in the business and actually has the best business sense. Now, how well do you think that son is going to take it? Just hearing it from dad that his younger sister's going to be in charge. It's going to be a tough conversation whether you do it privately or publicly, but at least if it's done publicly, everybody knows this is what dad's plan is, that that one child hasn't taken advantage of dad in coming to this arrangement, because now it's out in the open and you can have a discussion and dad can say, well, she's the most productive employee we have. She's the best educated one. And I had to make a tough call. She's going to be the president, but you're an important part of the business and you're still going to have a significant role. Look at the family dynamics to see what's going to play. And some clients are adamant one way or the other. It's my business. I'll do with it what I want. And they're just going to have to accept it. Other ones are, we don't want to fight in the family. These are my reasons for it. Let's get it out in the open and see where it is. And if we need to make adjustments, see if adjustments can be made that make economic sense to do it.
I think that's really interesting and somewhat counterintuitive, because I think most people would assume you do private conversations, but that idea of transparency and everyone being on the same story, even if it's a difficult story, sounds pretty important. And also, I know that following a death, there's often a question of undue influence, that some child was too close and got things bent their way because they had the ear of the parent, particularly when the parent's quite aged. So having a group conversation might possibly, in certain circumstances, be the best way to go.
Right, because, for example, if a disproportionate percentage is going to one child and everybody hears it and hears dad's reason for it, then they realize that was an intentional decision that was made. But if it's kept quiet, then after death, they see one child has got a disproportionate distribution, and they're going to assume that child took advantage of dad or mom, whoever the case may be, to get more property.
Right.
But different professionals differ on this. My way, isn't necessarily the right way. And clients do what they want to do. You can give them their advice. They know their family better than I ever will, and what makes the sense. I can tell them this is the advantages of full disclosure in a group. This is a disadvantage. Here's the advantage of talking privately. These are the disadvantages. You need to decide what works best for your family, because you're the one that has to live with them. I don't.
Or equally, I feel like it's everyone's responsibility to imagine that day after they die and what is going to happen with the family members. And so few people do that. Just say, well, what is Joe, the oldest son, going to think when everything goes to when the business goes to the control of the younger daughter? What is going to happen? What conversation is Joe going to lawyer up, or like what's going to happen? But to even imagine that, very few people do that. Right.
Very few.
I'm curious, are there any questions that you get over and over again that you kind of go, gee, I really wish I could get to people before they even pick up the phone and call me so I could answer this question before they even ask it?
I deal a lot with wrong information.
Mm-hmm.
Not necessarily the same question, but wrong information. Everybody gets advice in this area for free from someone who doesn't really know the area. For example, bankers will tell them one thing, and a lot of times it's completely wrong. And same way with other professionals, or they don't know the nuance, or somebody will say that something has happened to somebody who they think is similarly situated, and this is a certain result, and they will think, okay, that's the result that's going to happen for me, And they don't realize that was either the planning that was done that caused that result, or no planning was done that caused that result. Now, one of the common questions I get right off the bat is, well, how much is it going to cost to do an estate plan? It's not like a loaf of bread. I mean, if you ask me how much a loaf of bread costs, I can give you a good answer. So this is the way I deal with that question. I ask them, can I ask you one question first before I answer yours? They always say yes. My question is, how much does a house cost? They pause, and they will invariably say, well, that depends. It depends on size of the house, fancy of the house, where it's located. I said, exactly. You understand estate planning now. The answer to the cost of the plan depends. It depends on your family situation, your financial situation, your goals and objectives, how fast you can make decisions, how long I have to meet and explain things with you, how much tax planning we're going to do, how many levels of trust planning are we going to do? Are we going to have cascading trust? We've talked about the revocable trust. So at the death of the person die, are we going to have a trust for the surviving spouse? Then at the death of the surviving spouse, are we going to drop the property down in equal shares to the children, lifetime trust for them, so that we protect the assets in the event of divorce, creditors, or estate taxes? Then at their death, is it cascading down to their children and further trust? Are we going to put various special powers of appointment in the trust so people can take the property out of trust and move it in a different direction? So that is the one recurring question I get an awful lot is, how much is this going to cost? Same with probate. If somebody comes in there and we're talking about probate and a will, and the first thing out there they ask is, well, how much is this going to cost? And I say, well, at least let me read the will and see what the will says, because by looking at the will, I can tell whether it has a self-proving affidavit, which means witnesses don't have to appear in court in Texas. The self-proving affidavit eliminates the need for witnesses to appear in court. If it doesn't have a self-proving affidavit, cost is going to be much greater, because now I have to track down the two witnesses and get them to appear in court. Does the will provide for independent administration? If it does, then I know we're not going to be filing a bunch of applications in the probate court to do things. But if it doesn't provide for independent administration, and we can't get all the beneficiaries to agree on independent administration, I know every major action in the estate is going to take an application to the court and a court order in order to do it. So then I can start to say, okay, you've got a self-proved will. You've given me a list of the assets that the decedent had. I think your range is here. Now, if I've got a will that's not self-proved, a bunch of beneficiaries, the witnesses are going to be difficult to locate because the person executed the will one place. Now they've moved to Houston, and we're going to have to track people down, out of state, up in Missouri. Chuck moved to Texas. He has a non-self-proving will. Chuck's wife comes in, wants to prove that will, and I see the two witnesses lived in Kansas City, Missouri. So now we need to contact them. Now, they're not going to come down to Houston for a probate hearing. So in order to get their testimony, we would have to do a deposition on written questions to get their testimony.
These are people who may have signed a will 25 years ago, and then you got to find them and send somebody out to track them down. Did you really sign this? That's what's going on here? That ain't a cheap process or an easy one.
Part of what we tell clients that estate planning is a journey. It's not a destination. You're always going to be traveling, and every now and then you need to stop in at a rest station and have your plan looked at and then continue on your journey. It's not a one and done kind of arrangement. So that if we see somebody like you just described, they've come in and they've got an old will and it's done out of state, even if they said, my financial situation's relatively the same, I want to benefit the same people, I really don't need to make any changes, then I explain to them, well, you can take that approach now and not spend anything, but here's what's going to happen after death. We're going to have all these problems. Problems mean money for your estate. So you want to spend a little now with me, or do you want your estate to spend a lot after you pass away?
Okay. Steve, you used a couple terms I want you to define for people. What's independent versus dependent administration?
Okay. In Texas, there's two kinds of administration. First one's independent. That is basically free from court control. Not every state has independent administration, but Texas does. If you provide in your will for independent executor, for example, if my will says I appoint Chuck as my independent executor, that provides independent administration. That means after Chuck is appointed as independent executor, the only thing he is required to do is give notice to the beneficiaries that he's been appointed independent executor. He has to publish notice to general creditors, and he has to file an inventory or affidavit in lieu of inventory. But everything else, he doesn't need court control. For example, if Chuck wants to sell a piece of real property, he lists the property as independent executor, does the sale, collects the money, puts it in the estate account. Contrast this with a dependent executor, subject to court control. Now, Chuck wants to sell the real estate. He does an application to sell real property. Court says, all right, you're authorized to sell the property. So Chuck goes out and lists the property, and now a sale comes in. Another application is filed to approve the sale.
Wow.
And after, then the court then will approve the sale. Then after the sale is made, you have to do a report of sale to show that the property was actually sold and you actually got the money that you were supposed to get under the terms of the contract. So dependent administration is a lot of work and expense. A dependent administrator has to file an annual account every year with the court, listing every transaction that the estate engaged in, money coming in, money going out, assets on hand. So if the estate goes on several years, you'll have several annual accounts. Now it's time to distribute the estate, and because administration's wrapped up, you have to file the final account. All the beneficiaries have to get notice of the final account and have the opportunity to object to the final account, what the executor administrator that's dependent has done for the period of administration. So it's a very cumbersome process if you get dependent administration.
Ladies and gentlemen, this is the kind of thing you go, instead of going to a lawyer to get your estate plan done in Texas, you go on an online thing and you fill out a form to write your will. And there's a little checkbox. Is this a dependent or an independent administrator, right? And you check that, oh, dependent. Yeah, I want a court oversight of this. Does that happen, right? And then you're like, oh my God, what are you creating in the future?
I'm not aware of any of the online ones having the box to check.
Okay, all right.
A lot of them will, because they sell in all 50 states, so a lot of them aren't state specific. And what they will say is, instead of using the term executor, a lot of them will say personal representative. I appoint Chuck as the personal representative of my estate, period. And if Chuck can't serve, I want Sally. And if Sally can't serve, it's Tom. And they don't have the magic language for independent administration. Now, if all of the beneficiaries of the will agree on independent administration, that in writing, then a court will allow independent administration. But let's just say the person making the will gave more property to one beneficiary than to other beneficiaries, and they're mad. A lot of them, they won't agree to independent administration. So now you're back to dependent. So these beneficiaries can complain about everything that the dependent executor does.
Wow. But this is the kind of thing you have no idea this is going to occur after you die, right? If you don't talk to a lawyer, you don't talk to somebody who understands your state, you just barrel forward with some online, the consequences of such a simple thing as, it says personal representative, but that isn't actually the language in Texas. Personal representative is what I'm hearing. Well, then it's, okay, got to be fought over, or it could be fought over.
You could be, at the very least, it'll be more difficult than it needs to be, and you will pay more in fees to try to get it on track than you would have paid in the first place to do it right. One of the things that's important is if people are thinking about getting married and they're persons of means, either they older in life, been successful, got divorced and have property, or they're younger people, it's first marriage, but they've accumulated a bunch of property. Premarital agreements are very important so that you set the guidelines on how your property is going to be handled during the marriage. If you want to make sure your property is protected, then you make sure your premarital agreement has that property as your separate property, and that spouse doesn't have any rights in your separate property. You want income from separate property to be separate property rather than community. Your premarital agreement does that. Do you want the divorce to work out a certain way? You can put that in the premarital agreement. Sometimes you will have stages in there that are, if a divorce occurs within so many years, the surviving spouse or the other spouse will get X dollars. If it's number of years later, it's Y, and it's staggered. That's done where oftentimes one client's got a lot of money and the other one's not so much, and they want to protect their assets in the event of divorce, not get tied up in a long drawn out divorce proceeding, because although it's your separate property and you can establish it, you still can get tied up in a divorce proceeding a long time. Whereas in a premarital agreement, you can put certain provisions in there that at the end of the day will make it not cost effective for the other spouse to fight to try to get more than what the agreement provides, because it'll tag them for the attorney's fees for wasting everybody's time and running up the expenses.
So consider a premarital agreement, even maybe if it's a tough conversation during the romantic phase of life, because it may save a lot of arguments later for everyone in the family. That's what I'm hearing here.
That's exactly right. I just went through this with one of my good clients this year, who was a widower and had lost his wife, and about 7 years ago, and he had done well in life, and he was marrying a woman who has not done near as well, and she had trust issues, and he had talked about doing a premarital agreement, was planning on doing it, but then she did the boo-hooing about him not trusting her in life, and he decided not to do a premarital agreement. Well, they ended up getting divorced after a few years, but the property wasn't that hard to identify really what was his that he brought in because of the record keeping. But because she didn't like the result that was going to happen, she kept changing attorneys and drawing out the process. And just to end the process, he had to, let's just say, give her a bonus to get her to go away. Whereas if he would have had a good premarital agreement, he wouldn't have been in that situation.
Okay.
Mhm.
Let me just, before, I wanted to ask you also, Steve, but define a trust for us, because a lot of people don't know what a trust is. And we mentioned trusts and revocable trust and irrevocable, but just in a couple sentences, define that for us. What is a trust?
Okay. A trust is a relationship where property is held for the benefit of someone. The person who creates a trust is called either a grantor, a settlor, or a trustor. Those are the creators of the trust. The person in control of the trust property is the trustee. Think of the trustee as a manager, but the trustee manages the assets that's transferred to the trustee. A trust has a beneficiary. That is the person who's entitled to the economic benefit from the assets the trustee holds. In a revocable trust, the three hats can be held by the same person. If I create a revocable trust for myself, I'm the settlor, trustor, creator of the trust. I make myself trustee of the assets I transfer to myself as trustee, and the person who gets the benefit of the assets held in trust is the beneficiary. So those are the three relationships that are involved in a trust. A trust is not a legal entity. When people talk about trust, they think of it as an entity, and frankly, it's easier to think of it as an entity like its own little company. Because if we're dealing with a corporation, we know we've got the owners that are the shareholders. We've got a board of directors that sets the policy, and then we've got the officers who implement the policy. So for a point of comparison, so people can understand trust, I kind of like to use the corporation analogy to compare. So I said, well, in a trust, think of it this way: the person transferring the property and creating the trust is like they're the owners. They're the owners of the property. They're the beneficiary, but they're also the creator of the arrangement. The person in control now is like the board of directors and the officers, that they manage the property for the benefit of the owner. And other trusts, the roles will be different. For example, a lot of the planning we do is irrevocable trust, where the parents are trying to get assets out of the estate for estate tax purposes, so they're not going to be taxed in the parent's estate. So the parent will be the settlor, grantor, or the creator. The trustee, usually for tax purposes, the parents are not going to be the trustees, because we don't want to have too many strings attached to the assets and take a chance of the pulled back in the parent's estate. So usually some party is the trustee, at least until the child reaches a predetermined age, and then the beneficiary is the child. So there we can have three different hats for three different people, whereas in the revocable trust situation, a lot of times three hats are worn by the same person.
That was a fabulous explanation. Thank you so much,
Love it.
Steve. And thanks so much for your time today. Folks, if you are in Texas, if you're thinking about moving to Texas or you have property in Texas, you might want to talk to Steve Clausen. Steve, how can people get in touch with you?
Okay, well, I'll give them my direct phone number first.
Okay.
713-825-0994. You call that number, you'll get Steve.
Okay.
I can confirm that is true. I have called that number and got Steve.
And or you can email me, S. Clausen, that's CLAUSEN, at Hopkins, HOPKINS, Centrich, CENTRICH.com.
All right, fantastic. Well, we'll make sure to link to that in the show notes and in the description if you're watching this on YouTube. And if you are happening to watch this on YouTube, be sure to like it, subscribe it, and if this video was valuable to you, please share it with your friends, or if you're listening on your favorite podcast app, please give it 5 stars in the review. That really helps people find this show. Again, I can't thank Steve Clausen enough for being here today. It's been a delight learning more about the nuances of Texas, and we want to thank you for making it to the end of another episode. So be sure to join us next time, and we'll be talking about a new state, a new project, something related to estate planning, but you're not going to want to miss it either way. So until next time, take care.
Thanks for listening to Essential Estate Experts, presented by Screenfire Media. Please remember to like, subscribe, ring the bell on YouTube, and rate us 5 stars on your favorite podcast app. It really helps. For more information, please visit screenfiremedia.com. Essential Estate Experts is copyright 2023 Screenfire Media, all rights reserved.